Okay. Hi, everybody. My name's Chase Silvert. I'm with the Hawaii State Council on Developmental Disabilities. I am our legislative and community liaison. I do all of our policy work is really what that means. Today we're going to talk about alternatives to guardianship. Um, these are like the main areas that we're going to kind of cover today and hopefully things you can walk away from. Essentially, we're just going to do an overview of guardianship and conservatorship and any alternatives to those processes. One of the big alternatives, which is kind of spoiler alert, is we have supported decision making, which is basically the national best practice for alternatives to guardianship. And we're going to go into a lot of detail on what that is, how to do it, things like that. There are also some other key tools that you can be using, like power of attorney, contracts. You can also use other financial tools since guardianship. It can kind of be covered by supported decision making and power of attorney, but the financial tools are things like able accounts, representative payees, and trusts and things like that. Uh, so, introduction to guardianship and conservatorship. So, just for folks that maybe aren't familiar with it, guardianship is essentially the legal process to appoint someone for an individual to make decisions for them. It is a process that does strip the individual of a lot of their own individual rights and their own individual ability to make decisions. But in a lot of cases, and in many cases, that is what it needs to happen so the individual can stay safe and can have appropriate guidance. Later, we're going to talk about alternatives to try either before or in conjunction with guardianship. But that's what it is. Conservatorship is the exact same thing, but specifically for finances, essentially. So it just takes away the individual right to the person to their finances. So if they go to a bank or they try to spend any money, they essentially can't without their conservator also signing for them saying they can and cannot do those things. So types of guardianships, this is Hawaii specific, I should say. And for a lot of the information we're going to be sharing today, this is all Hawaii specific. For types of guardianship, we have full guardianship, which just means that you are taking full guardianship of the person. They do not retain any right to make any kinds of decisions in their lives. Limited guardianship is basically in certain areas they can retain control and making decisions in that regard. And then you have temporary guardianship, which is typically like emergency guardianships, which is just for a short period of time, you are the guardian of that person. Sometimes this can happen with mental health crises and short-term things like that, and it doesn't have to stick forever. We also have conservatorship, different types. So really quickly, this is just a little more information on conservatorship. It's when the court appoints someone to manage a person's money or property. The benefits of this is that it ensures financial security as it's the other individual has to basically double check and be the final say on all financial purchases. But it does limit the individual person's capacity to spend their own money and make those kinds of decisions. So alternatives to guardianships, there's a lot. Not all of them are comprehensive, and by that I just mean, some of these alternatives are going to be only great if they're used in conjunction with others because they're only going to cover pieces of what a guardianship would normally do. And so you can combine a lot of these to kind of altogether replace guardianship and or supplement it to just allow the individual to keep as much capacity as is appropriate in every scenario. So some of these real quickly are supported decision making, which I will get into more in just a little bit, so I'm not going to go too much into it right now. Power of attorney, which we'll also get into, but power of attorney really briefly is just a way that two people can sign a contract and somebody else can essentially be a surrogate decision maker for the person. So it's really good for people that need help making decisions, or for example, a parent can sign a power of attorney with their son or their daughter, even if they're past the age of 18, and that would still allow the parent's signature to work in like medical cases and financial situations and on all these different kinds of decisions, and it gets you right to certain kinds of information. Release of information and protected health information. Basically, we get asked about this a lot. Essentially, once you turn 18, this comes from parents as well, is that you don't really have a right, even though you're family, there's a lot of information you kind of don't have a right to anymore. And so these releases of information is what can guarantee that if your child's ever in the hospital or has medical needs or has financial needs, these types of releases of information agreements are what can get you that information regardless, even if you don't have guardianship. Living will or advanced directives is going to be very similar to conservatorship alternatives, and we'll get into all those a lot more. You have advanced instructions for mental health treatment and legal and healthcare support. So these are all things we're going to get into more detail into. So options for representing an adult student with disabilities in special education. So something that we do hear a lot is, especially for people with IDD going through our school system, they can, oh, and I should say IDD is intellectual and or developmental disability. Um, what can happen is they can actually stay in the DOE system or in school until the age of 22. And a lot of people have expressed concern with, technically they become, in the eyes of the law, an adult before the age of 22, right? At 18, they can start making certain decisions for themselves. And there's rightfully some concern around what can a parent still do, even though they're still responsible for their child. They are also technically an adult. And so power of attorney and educational representatives are great alternatives to allowing the parent to still have the needed kind of say and sway in their child's life and kind of continue to support them throughout their life. So power of attorney for special education is so that the student and the parent can make decisions together. Essentially, this contract has to be written, witnessed, and or notarized. We always kind of just recommend getting any of these kind of contracts notarized when possible. It just has a little bit more weight to it. And it can be revoked at any time. And this kind of agreement is essentially allowing the parent to continue to make decisions with and for the individual, and on behalf of the individual. An educational representative, very similar kind of contract, but this one is specifically for students who cannot make decisions. It typically requires a doctor's statement of incapacity, and this one is a little more heavy-handed, but not necessarily in a bad way. It's just for individuals that really cannot be making decisions on their own, and the parent does need to be making the decisions for them. So other alternatives. You have supported decision making and power of attorney, which we're going to get a little bit more into now. So for supported decision making, uh, really quick, the definition, supported decision making is a process that allows individuals with disabilities to make their own choices with help from trusted supporters. And the purpose of supported decision making is really to allow and empower the individual to keep as much autonomy and self-capacity as is appropriate and as is possible for these individuals. Um, Capacity is always a very interesting question with people with intellectual and developmental disabilities. And the intent of supported decision making is to allow those individuals to just have as much autonomy as is just possible in our day and age. And in general, I mentioned this a little bit earlier, it is the national best practice for alternatives to guardianship. And in general, it's something that we recommend is either used before and instead of guardianship, and or it can be definitely used in conjunction with guardianship. So even if you're already the guardian of your child or of any other individual, you can still today start using supported decision making and allowing them to make whatever decisions seem reasonable. So why is it so important? I covered a lot of this just now, which is that it promotes independence and self-determination, it encourages inclusion, it supports their individual rights, and it can always be used with guardianship. And in general, it's just from at least the experiences that we've had and from the stories that we've heard, it's a very, very humanistic way of just making decisions and working with an individual for them to have the most self-determination they can. So how does it work? It seems really simple, and to some extent, it really is. You pick your supporter, which is just basically when you sign a supported decision-making agreement, the person who is signing the agreement is basically saying, I'm signing up to be a supported person for this individual. And so the individual gets to choose who they want, and typically we encourage that you choose more than one individual for different things. So you might have a supporter on your financial decisions, you might have a supporter on your day-to-day life situations, things like that. Don't necessarily have just one person for all of your things. We recommend that you kind of build a community around yourself and have a community of supporters in this scenario. A great example is a lot of people will choose one person who maybe has some more medical knowledge. So maybe a friend who's a doctor or a friend who's a nurse who has more background in medical issues, and then they become your supporter for medical issues only or specifically. So it can be more than one supporter. It can just be one, but we always recommend as many as you feel comfortable and work for you. And then you have to decide how they're going to help you, which is kind of what we just discussed, which is it going to be on medical things, finances, how you communicate with people? It can be really what you need help with. And then the way that the process works is you have to, half is an interesting word. You have to work with them to make decisions. You got to talk with them. You got to get their opinion. They're going to help you talk through what you're trying to figure out and what you want to do. A good example is like, let's say I want to move. I live in Aiea. I want to move into Waikiki. And there's so many different aspects that go into that question. So I speak with my financial person. Well, can I afford to do that? I speak with my day-to-day life person to be like, well, what's my commute to work going to be like? Is it better? Is it worse? Things like that. And then just depending on kind of how you talk it through with everybody, they're always supposed to give you their opinion on what you should or shouldn't do, but give reasons why, not just tell you why. And then once you talk it through with them, at the end of the day, with sport decision making, it's still your choice on whether or not you want to do this. Um, and that is kind of the general need. Every supported decision-making agreement is going to be unique and different to itself, and it can always be changed. Um, this is an example that we have of a supported decision-making agreement. If you scan the QR code, you're going to get a more detailed example that you could use. We at the Hawaii State Council do have currently a drafted version of a contract that folks could use. Sorry, we call them agreements. Um, but we do have a drafted version that you folks can reach out to us. And I believe at the end of this presentation, our email will be there, and we can provide you with that specific updated agreement that we have. Uh, and I think I might get into this a little bit more later, but we did actually just pass a law this legislative session, and it's already been signed in and passed completely, so there's no chance of it getting vetoed, that supported decision-making agreements are now legally recognized by the Hawaii State, um, I guess, law or agency, institution. So these are legally backed up agreements, and that bill did pass this year. So these do have a little bit more oomph, and now we're just going to be doing education to make sure that financial institutions and medical institutions know about these agreements. Because a boilerplate thing that is in all of these agreements essentially is that a lot of the people that help you make decisions are able to access information that is helpful to make decisions with the individual. So if I'm the finance person and I sign this agreement that I'm going to help this person make financial decisions, you should be able to walk into a financial institution with this agreement and be like, hey, I'm John Doe's supported decision maker, and he's asking me finance questions. Can I see like how much he has in his bank account because he says X, but it doesn't seem like that, adds up. And then you should be able to kind of double check things. The financial institution should be able to reach out to you if they have any concerns or if there's like a fraud alert going on. So these are things that, in our community, we're going to work on getting awareness around, but that's what the legal beefiness of it kind of allows for. These institutions should readily accept these agreements and allow for you to see that kind of information. Now, just because there might be some fraudulent concerns, a supported decision-making agreement does not allow you to withdraw, move, take money of any kind. It just allows you to see information. Same with medical information. You cannot make the decision for the individual. You cannot sign things for them, make medical decisions of any kind, but you can gain medical information about them that helps you make decisions with them. Or, if they ever have a medical crisis, you're able to get that medical information about what's going on with them so you can be there and support them through it. So that is something boilerplate that's worked into a lot of these agreements that make them very useful. So yeah, so I just talked about the legislation a lot. So the bill was HB 320. If you scan this QR code, it will take you to the bill. The bill has a lot laid out in much more detail on what has to be in the agreements. If you use the agreement that we've drafted, it will check all the boxes of what has to be in there from the law. And we think it's a very good template to kind of start from. But you can always alter it to do different things, do less things to some extent. So we just highly encourage everybody to kind of look at this law, look at the agreements, and debate if supported decision making is something that is going to work for you folks. From what we can tell, supported decision making is really good for anybody to any degree. We really highly encourage it, even if it's just to make smaller decisions or not the major life decisions, but some decisions, as long as we're increasing someone's capacity and we're working with them to at where they're at, we're meeting them where they are, is really the intent of supported decision making. It doesn't have to be this grand sweeping thing. It can be just little decisions and giving them back just a little bit of autonomy in your day-to-day life. It's much more of just a practice of supporting the individual in making decisions in whatever is most reasonable. So switching gears a little bit, you have things like power of attorney. Now, before I get into these details, the reason we wanted to kind of bring up these other alternatives, so there's supported decision making, there's power of attorney, there's other things that you can combine all these things with, like representative payee, which again we'll get into more detail. But the reason we bring these up is because at least in the state of Hawaii, guardianship is expensive. It's about $3,000 to $4,000. You typically need a lawyer to get guardianship over somebody. And because of that, that's not realistic for all families, especially if you have 3 or 4 kids. And if you do need to get guardianship of all of them, that's a lot of money over time. And a lot of people can't afford that money. It's also a time-consuming process. It also takes anywhere from 4 to 7 months to become someone's guardian. So if you need this done immediately, or you need it kind of done in a fast fashion, it's not going to happen very quickly, which is not something people are very aware of. And so we kind of offer these alternatives as one, it's cheaper. Two, it allows the individual to keep more autonomy if it's appropriate. Um, and they're fast and cheap, essentially. For a power of attorney, it's just a signed agreement. You can get it notarized, and essentially to have a lawyer and have someone draft it, it might be a couple $100 versus $3,000 to $4,000, and it can take effect immediately. So it's something that you could get done in less than a week. Um, and the way a power of attorney works is it's basically just a legal document that allows individuals to appoint someone to assist and or make decisions for them. So I will come out and say one of the biggest differences between power of attorney and guardianship is that the individual still does maintain the right to make decisions as well. So essentially, with power of attorney, the person that is assigned, let's take a parent and their child that's above the age of 18, the parent can make decisions for the person, but the individual can also still make decisions. And another way of saying that is that the individual's signature is still good. And I know it's a question we get a lot. What happens if there are two conflicting decisions? It will always, at least in the sake of in the process of a power of attorney, it will always be the individual signature that is stronger than the surrogate decision maker. Um, so that is something to consider when you're going through all these different options. But some benefits of power of attorney is that it maintains the individual's decision-making rights. It can be very flexible. It can be changed very easily. It can be canceled very easily. And by that, I mean literally if the individual just takes the contract and rips it up and says, I don't agree with this anymore and I don't want it, the contract is technically terminated. Now, there is some reasonability in there if it's like a moment of mania or it's a moment of just like heated passion and then the next day they're like I didn't mean that. The contract doesn't have to be null and void. It's all about intention and reality. um it's also a very person-centered approach, and it can also be used in conjunction with support decision making. So you can do support decision making, still become a power of attorney of an individual, and go that route. So it makes a really good pairing. Also, power of attorneys typically give you access to medical information, financial information. Every contract is specific. You have to write that in there. There are many different templates for power of attorneys. It's another contract that you could reach out to our office and we can give you a template that we've used before, and you can go that route. So how do all these kind of tools come together, and who decides and who is it used for? So when it comes to sport decision making, it's all about the individual making the choices, and really anyone can use it in any area in conjunction with anything. The court does not have to be involved in any way. There's no hearings or anything like that. And you can get it notarized. It doesn't have to be notarized, but it does have to be witnessed. Um, the power of attorney is the individual and the appointee who get to make decisions. It is used for money, finances, health, legal, everything above. And the court, again, does not have to be involved, but it typically does have to be notarized. Guardianship, it's completely court. And it's used and the person who gets to make the decisions is whoever the guardian is. And you do have to go through a guardianship hearing. There is information you have to go through. And like I said before, it can be expensive and it can be lengthy. Same exact process with conservatorship. You go through, I believe, the probate court, and it can cost money, but conservatorship is specifically for financial issues. And I will point out supported decision making can be used with all of these. So if you're the conservator, the guardian, or the power of attorney, you can still do supported decision making with all of these. So what are some financial tools to go along with everything? So let's say, because in the realm of capacity, you have your day-to-day life decisions, you have where you want to live, what you want to do, where you want to work, but you also have to be able to manage finances, have money to pay rent, have money to buy food, do all these kinds of things. So we've up to this point talked a lot about how you make your day-to-day life decisions and who gets to make those and make your medical decisions. This is more about your financial side of your life and what can we do around that. So the version of guardianship here is kind of what we mentioned before, is it's conservatorship, where you take completely the person's right away to their finances, and you basically are the only person who can choose how, when, and where they spend their money. But there are other tools that you can use as well. Sometimes they can be used in conjunction with conservatorship, sometimes they're used instead of it. So for example, the other financial tools that exist are ABLE accounts. ABLE accounts are great, especially for people with intellectual and developmental disabilities. One of the main requirements of an ABLE account is that you have to have a disability before the age of 26. That's what makes you eligible for these accounts. They have really good tax savings. And I am going to go more into these ABLE accounts shortly, so I'm going to leave it there. They're really good for people that have disabilities and are basically on poverty-based systems, because they help you essentially save money but not be punished by being kicked off Medicaid and things like that. But we'll get more into that. We also have representative payee. Now, this is a really good one, which is that if, for example, you're an individual on Social Security, but specifically SSDI, so the disability part of Social Security, if you become the representative payee of an individual that basically requires SSDI, that's the only income that they have, and that's where they get all of their assets from, you have access and control of all of their money. So you're kind of pseudo a conservator already, but you don't have to go to court, you don't have to go through that process, and you become their representative to the Social Security. The money goes into your bank account, and it is your responsibility and duty to spend that money in the best interest of the individual. And the individual has to sign that. They have to agree that that's what they want you to do, unless you're already the conservator and the guardian of the person. But otherwise, the person does have to agree to give you that right to make those decisions for them as their representative. Trusts. So trusts are very complicated. Many people have trusts, have special needs trusts, and this is a way of leaving children or other people your finances without it necessarily devastating their Medicaid and Social Security and things like that. Um, while I'm not going to sit here and say I'm a trust expert, there are many lawyers in the state of Hawaii who can talk in more detail about special need trusts, how they work, living trusts, wills, estates, all those kinds of things, especially when it comes to Medicaid. I believe you can own a home and have one car, and it doesn't count towards your Medicaid assets. But it's all a very complicated thing, and we do recommend, if you're going to go the trust route, hire a lawyer who specializes in these things and get a trust sorted out. And that's the best way to kind of handle leaving information or leaving finances to your children after you pass away. Also, another kind of less, I guess, formal way of having money working with individuals is that you can just have joint bank accounts that you put money into. So you can have a joint bank account, you can control the finances or how much money you have, and then you can just put a set amount into the bank account of the individual. And it can be a way that you still have access to their bank account. You can put money in easily or take money out and then kind of work with them on their finances, their financial control. So if you have an individual that you're working with that isn't great with finances but is trying to get better and you're trying to work with them on it, sometimes joint bank accounts are all they need because you can kind of siphon in how much money goes in, allow them to make decisions, see how it goes, work with them on, why did they spend money doing this, this, and this. And sometimes it's just a really easy solution to do it that way. So able accounts, which I personally love able accounts. I think that they really help out, especially the IDD community. So essentially, able accounts stand for Achieving a Better Life Experience. We do have Hawaii specific able accounts. The DD Council has worked very hard to make sure that we have Hawaii based accounts. They can help you have savings even when you're on programs like Medicaid, food stamps, and Social Security, and they make sure that you don't lose a lot of those benefits. They can impact the amount of money you get from Social Security, and things like that, but that's only after you've made, I believe, over $100,000. You have to have over $100,000 in your able account before it'll start affecting your SSI benefits. So it, it not many individuals reach that amount. I wouldn't even reach that amount, so that's a goal for everybody. You can contribute up to $19,000 per year into your ABLE accounts, and there is an exemption to actually contribute more if you're working. So there are working exceptions. And then from your ABLE accounts, you can spend your money. You can have a card or you can withdraw money from that ABLE account, and you can use it on medical costs, education, housing, transportation, and a lot more. And in general, there's just a lot that you can use your money from able accounts are. Yes, there are rules specifically around like what you can use it for, but they're very broad for the most part. You typically justify most purchases coming from able accounts. And we haven't really heard of people having many issues with it. There is something we should mention, which is that there is technically like I believe it's like a Medicaid clawback rule in able accounts where if you do have an able account and you have money in there and you pass away, Medicaid can take money out to basically pay any overdue bills or any money that they believe they're owed due to your medical expenses that they paid for through Medicaid. This is a clause. From our knowledge, it rarely, if ever, happens, and when it does happen, it's not an absorbent amount. They don't wipe out the accounts. It's worth knowing. It's worth knowing that it is a technically a risk, but in practicality, it's just not something that really happens. At least not what we've seen. And yeah, also please another QR code. Please scan this QR code to visit the Able account website and apply, open up an Able account today. We're trying to get as many people on it as we can. And we have questions. Before we go to questions, I'm actually going to just kind of summarize really quickly. So, when it comes to supported decision making, alternatives to guardianship, guardianship itself, and then these financial things that we just spoke about, there is what we kind of want to say is that a lot of these should be used in conjunction with one another. So you can pair able accounts, representative payee, supported decision making, power of attorney, and you can sign documents for the individual. You can get medical information. You can help them with financial decisions. You can make financial decisions, and you can help them save and still spend money appropriately. So it's just one of those things where you can combine a lot of these together to do a lot of things to help the individual live the best quality of life they can. Now, we're not going to sit here and say that nobody should be under guardianship. There is an appropriate time and place, and if they are going to be under guardianship, we still recommend you use supported decision making whenever possible and however possible with the individual. And we just always recommend using all the tools at your availability. And please contact us, call us, any questions about ABLE accounts, SSI, Medicaid, supported decision making, all of those things. That's what our office is here for. So please give us a call. Let us know what we can do for you. And specifically, if you have any questions on how to actually practice support decision making, because it is a newer thing to our state, we have an expert. Her name's Julia, and she's happy to walk anybody through more details of how to do support decision making in a very practical, literal way. And we are working on a toolkit to come out with support decision making. So this is how, follow this toolkit and you can start practicing it today. And we also, like I said earlier, have those drafted agreements that people can use. And that's all I got. Thank you, everybody. And just really quick in conclusion, this is just the contact sheet. So we're with the Hawaii State Council on Developmental Disabilities. That is our website. That is our phone number. And I believe on that website is also my contact information. I'm Chase Silvert. So just look me up and send me an email or just call our office and ask for me, and I'll answer any questions. Thank you.